Everybody, very welcome in our class. Just by way of introduction, because this is a recorded session, I wanted to tell you that in fact what we are discussing today is the fourth dimension of the overall subject matter area: freedom, security and justice. The first dimension we discussed in the Monday session, when we discussed the question why, how, when did this format of cooperation, when started it to be developed at the European level. And I explained to you and we discussed that it had everything to do, a logical connection with the primary objective of the EU cooperation as it started in the 60s, which was the achievement of the internal market, including this famous fundamental principle, free movement of persons, which means that the citizens of EU member states are entitled to travel freely, to reside in other member states, and not only to travel, but also to have access to the market, the labor market, to bring their families, to stay there in a sustainable manner, under the condition that they can provide in their own financial resources and also are secured by a health insurance. The second day we discussed in fact more particularly the details of movement of persons, and in that context we also paid some attention to this new concept which was in fact introduced in the Maastricht Treaty in order to bring European Union cooperation somewhat closer to the ordinary citizen, which was European citizenship. And in that context, we did not only discuss what European citizenship has added to the acquis of the internal market with regard to free movement of persons, but we also discussed the position, we started to discuss the position of third country nationals on or in the European Union, but then primarily either as family members of a primary beneficiary, so an EU citizen, or as caretaker of minor children having the nationality of an EU member state. Yesterday, which was in fact the topics which we should deal with last, police and criminal law cooperation, is obviously also an important dimension of the area of freedom, security and justice. So the fact that we abolished internal border controls, that we try to protect our external borders, is of course an argument to try to cooperate also with regard to international crime. And we discussed yesterday, of course, not each form of international crime, but really those forms of international crime having an international character. And then the topic of today, asylum, immigration, is in fact on our agenda and in our mind each day. So when you come home and you look to the television in your nice hotel, you first of all will be confronted with the news regarding the NATO summit, which meets today in Wales, Newport, where they are discussing three topics. The first one is related to Afghanistan. All the events haven't taken place there, all the unrest, the conflicts, which has not yet come to an end. A source of unrest which also have given rise to movement of persons, migration movement from east to the west. The second one, which is a very deplorable one, because all these events are taking place at the moment in Ukraine and Russia, is the unrest in the eastern part of Ukraine, which gives rise to the question to what extent and how the NATO will be able to develop a common position in this domain. Unrest at our external borders, because Ukraine is a country, is a European country, however it's situated at our external borders, so there is a security interest here at stake, and more particularly because of the threats, military threats also. It's a direct threat for our security and justice system. And the third topic which will be discussed is in the NATO context, the difficulties and the continuous conflicts going on in the Middle East, and more particularly the upcoming activities of the so-called Islamic State, and which also gives rise to conflicts between people, on ethnic grounds, on religious grounds, whatever, and giving rise to unrest in our neighborhood. Why this introduction? Just to tell and to discuss with you that in fact asylum immigration is on our agenda because Europe is one of the, at least from a Western perspective, one of the rare islands of stability in the world. I mean, we live in a period of peace, of stability. We lived in a period of prosperity as well because of the economic crisis. Of course, that argument is not so valid anymore, but nevertheless, peace, stability is the determining factors of our existence here. So we may be glad as citizens of EU nationals to be able to live here in Europe. And for example, you can refer to other areas as well, but again, from the Western perspective, United States, Australia, and Europe, Canada, but then I think you refer to only a few islands of stability, and of course, in view of the continuous tensions in the world, and now also in our close neighborhood, I think it is at least comprehensible that Europe has become a source and a destination for those people who are looking for a better future. It's as simple as that. And for example, when we are referring to third country nationals who want to come to the European Union in order to build a safer life, and the Ukrainians argued when they demonstrated in November in the Maidan Square, we want to live in a secure world inspired by European values, etc., etc. So it's either because they have to fear for their life and a family in their home country, or they want, as an economic refugee, to try to find a better future in the European Union, or they are simply, what is also possible, the victim of international crime. And of course, human trafficking is one of the most nasty examples of that. And there are so many people who in fact are suffering from this fact. So warfare, conflicts, violence, but also when we're referring to the Mediterranean, poverty, scarcity situation in Africa, the central part, but also the northern part, crime, terrorism, people without a real perspective to find a good future, they're coming to Europe. And that's the question, of course, and I think it's very difficult to explain to you the numbers of people who try to find refugees, refuge here. But I think there are, in fact, it's a huge number. When you ask the Italian authorities responsible to protect our border with Northern Africa, Maltese authorities, it's a huge number. But I think in total, with regard to asylum seekers, I have the impression we talk about 500,000 people a year. However, when it comes to illegal immigration, it might be easily a similar amount, a similar number of people. So today also, there are all kinds of incidents taking place in Calais, because there are many people, illegal migrants, who try to build a better future in England more particularly, and they have posted themselves now in Calais in order to try to catch the ferry boat to England in order to build there a better future. So I think with regard to illegal immigration, we also estimation could be 500,000. If you compare that to the number of the inhabitants of the European Union, I think at the moment you are 510 million. It's not that much, but it's nevertheless a problem. And it could be that the problem will not be solved in the near future. So we have really to take action and measures in order to try to solve all these problems. So with regard to what's happening in Eastern Europe, not only the tensions at the Ukrainian-Russian border, but also with regard to effects of international crime, the Mediterranean, this story which is taking place in Calais at the moment we are here discussing with each other. The question arises, how is Europe going to organize itself? Well, for that purpose, I turn firstly, because I refer to asylum seekers, migrants, maybe illegal migrants, maybe legal migrants. Legal migrants is also a very important category of people. And it could also be that the title for which they ask for, that they are similar, that we are confronted with perpetrators of crime. So asylum seekers, legal migrants, illegal migrants, and why not, suspects of crime. And we have to cope with these categories. Now my intention is now for today to discuss first of all, because that's the most important from a humanitarian point at least, the most important category of people, the asylum question, and then to discuss the migration, the migration aspects with you. Well, the interesting thing, of course, is when you are referring to asylum seekers, the starting point to try to protect asylum seekers was not the activities undertaken at the level of the European Union. The lawyers in this group know certainly what I'm referring at. After the Second World War, which gave rise to a lot of migration and horrible events with regard to movement of persons, the international community developed and adopted an important convention, and you know which one that was.
The Geneva Convention.
The Geneva Convention of 1951, which was complemented by a protocol text later on in the 60s. Important text. And the main objective of that convention is, because if you read the text, if you analyze it, it's relatively simple, full of interpretation problems in my perspective. But nevertheless, the important thing is those people who have to fear for their life because of their political conviction, and with them family members, etc., they need international protection worldwide. So once they present themselves to you with an application or a request for protection, and they refer to them as potential asylum seekers, they have to be protected on an automatic way. So it's not allowed to simply return them home or to send them back home, but you have to protect them. That, of course, internationally is a very important standard, and with regard to protection of human beings, perhaps the most important one. And of course, if I can explain to you that in the European Union, we have gone a lot further in this domain compared to the acquis of the Convention of Geneva, 1951. Nevertheless, it is this convention which is the text, in fact, the supreme text, which has to be respected by all members of the United Nations, so including all the member states of the European Union, for example. However, the interesting thing is, but in a way it's a consequence of tragic events taking place in the European Union, as I said, in the EU we have gone much further than simply trying to provide for protection to asylum seekers, people asking for asylum because they have to fear for their life. And in the course of time, I can also tell you, originally asylum was connected to your political opinion, your political activities. Over the time, we have provided a more broader interpretation to asylum seekers, all those who have to fear for their life because of respect of human rights and these kind of things. Nevertheless, in the light of what happened in the last decade in Europe, so these days, unfortunately, we experience violence at the Ukraine-Russian border, but in the last decade we experienced another very nasty conflict, which was the civil war in the former Yugoslav Socialist Republic. And in the Socialist Republic of former Yugoslavia, people left their home, left their society, not so much because they were ordinary citizens, they were farmers, they were businessmen or women or whatsoever, but they left their home not so much because of their political conviction, their activities or whatsoever, but their ethnic origin. And that was really something very harsh to experience. And it was in fact an inspiration for the EU to try to broaden the scope for international protection. And that is a notion which will come back when I will present you the sheets which I have prepared. That means that we have developed, next to the concept of asylum, application for asylum, the concept of subsidiary protection, subsidiary, and it's self-evident if you hear what I'm talking about. So it's an extra, it's complementary to the asylum that we have provided for subsidiary protection. In fact, they are referring, and that's also written down in the treaties, to those persons who are in fact displaced from their home. They have no relationship anymore with their home. In fact, the main reason was ethnic origin, but could be also for other circumstances. So we have provided this new terminology and provide for protection also for those who are not able to invoke the status of asylum seeker, but in this context, subsidiary protection. And I think that is one of the, well, the positive results of a very negative period in our European history, because that's what it is. And in fact, this period, the last decade of the last century in Yugoslavia, also presented another new aspect, that was the number of people who were leaving their homes. Not individuals, not people with their car or whatever, with their luggage and animals and I don't know what, but massive influx of people. And because of this, this character, the characteristic of a massive influx in the European Union, also Bosnia, Croatia, what we have experienced, we have provided in also an extra element of protection, which is called temporary protection. So those who in fact make a plea for international protection in the context of the events which we have experienced, which by the way we have not experienced since, also not now with the Ukrainian crisis, but in the Yugoslav period it was clearly the case that the Austrian border, Italian border, and also further on in Germany, also in the Netherlands, there were big numbers of Bosnian people, Croatian, asking for protection. And that's why simply if these people, if you were confronted with such an influx of people, we have agreed between ourselves to extend to them this issue, this idea of temporary protection. And then take the time, but in the meantime they have refuge, you have to provide them housing, you have to provide them care, etc., etc. And then afterwards we take a closer look what their status could be. Asylum seeker, illegal migrant, perhaps a legal migrant, why not? Could be somebody who is easily qualified to enter the labor market in one of the new member states. So in my personal surroundings of friends and relatives, there are people from these days who had a certain academic quality, who were able to find a place on the labor market and are now fully integrated in the society of the Netherlands, which is of course a wonderful thing. So, whereas at the starting point, and this is the main point at the international level, the Convention of Geneva, and that's the prohibition of refoulement. You are not able to send somebody back. So, refouler is to send back, isn't it? I think it's the literal translation even. So non-refoulement, that's the main standard, the prohibition to do that. Everybody, all members of the United Nations have committed themselves to respect that standard. And in the EU, we have done a little bit more. Now, of course, we have done a little bit more. That's, of course, easy to say, but how are you going to arrange these things when it comes to details? When you are confronted with individual requests for asylum, for example, And that's where I'm now arriving with a couple of my sheets. So asylum in the first place has a reference with other sides. Oh, here, my goodness, something goes wrong. But fortunately, duck. And then we start again. Here you are. So the UN Convention of Geneva, that's the first thing, and then, of course, the reference to European versus international law. And as I said, with regard to primacy, supremacy, it's the UN standard which is the overall, the supreme standard which has to be respected. Then, as I said, so when it comes to asylum seekers, how to deal with them on an individual basis, I switch first to this one and then want to show you this list. An asylum seeker who presents themselves in England or in the Netherlands or in these boat situation in the Italian territorial waters or in Malta or wherever it is, you have to find a connection, and these are all consequences of the internal market which you have created. The internal market has created a human space without internal borders. So you have to connect the application for asylum to a certain member state, which is the directive related to responsible member state to examine the application for asylum. Second one is that we became aware that in fact the definition of the UN is full of question marks, interpretation problems, which inspired the EU legislator to develop its own definition of what a refugee is supposed to be. However, at that moment, and this is a directive, but we will come back to it, I think of 2003 only, we try to involve and include the new elements. So not only an asylum seeker needs protection because of his political convictions, but all because of other kinds of threats, respect of human rights, and so forth. So in the broader sense, we try to find a common definition for the notion of refugee in order to be able to qualify somebody as an asylum seeker. Then certainly you have to provide for procedures, how to do it, deadlines, and more particularly and more importantly also mechanism for judicial protection. So people whose requests have been dismissed should be given an opportunity to make an appeal with an independent organ, obviously. It could be a tribunal, a court, but at least an independent organ. And after all, we have also to take into account, that's also a reference to temporary protection. People who apply for asylum have to be provided with protection also in the sense of housing. Children should be able to go to school. They have to be provided social aid, medical aid, and in certain circumstances even the asylum seeker and his partner should be allowed to enter the labor market. And all in all, that was the ambition of the EU, and that has been more or less accomplished in a period of 10 years. We try to develop what is called a common European asylum system, the CEAS, Common European. So that is and it has been achieved in two instances. 1999, that's the date of entry into force of the Amsterdam Treaty. 2004, that was the fourth period of 5 years, with, do you remember, the Tampere program as the policy guidelines from the European Council, which objective to be achieved in which period of time. So 1999 to 2004, and the other one was 2004 to 2009, which happened to be in the end the entry into force of the Lisbon Treaty. And now, more or less, we are able to say and to establish that we have achieved a common European asylum system. Now, to go back to this one, This is something which is, of course, a rather delicate topic because it concerns fingerprints. One of the first directives which have been drawn up required asylum seekers to take fingerprints of all their fingers, not only the thumb or middle finger or which finger, all the fingers, which gives rise to certain nasty, sensitive issues. But this is a regulation dating, well, it's mentioned here to the year 2000, so in the beginning of this first period of 5 years. And I mean, it's acceptable, I think. If you are applying for a new passport, you also have to deliver a fingerprint of your thumb, or for 2 fingers or 3 fingers. So, but it has given, in the practice, in certain member states, this issue has given rise to even legal proceedings. But so far, I'm not aware that the validity of this regulation is in danger or something like that. So that is the starting point. And of course, it's a question of identification. It's again the data bank, like we had the FIS, the Visa Information System, which we discussed on Tuesday. It is another one compared to the SIS, the Schengen Information System, where all information is collected with regards to third country nationals who we do not want to allow, we do not allow to admit on the territory of the European Union. But so this is in fact a first text which has been established and deals with fingerprints, with all the privacy problems connected to them. Then when it comes to this list, and we take them separately, responsible member state, definition of a refugee, procedures, reception. And then, at least that was the idea, you have a sustainable and integral kind of, you have developed an integral kind of procedure how to deal with applications of asylum. When it comes to the responsible member states, it is in fact relatively simple. I mean, I could ask you, what do you think should be the first point of connection when there is somebody who asks for asylum? For example, when he arrives here before the coast of Attica and asks here at asylum at the mayor of Legraina. What is the first connection? Of course, the place, the location where he enters the European Union. That is in fact the first point of connection. And that in many cases could also be the applicable criteria. But as it's mentioned here, this is in fact called the Dublin system. Why it's called the Dublin system? Because this text had a predecessor text, which was an intergovernmental concluded between a limited number of member states, and which was called after the city where the Nice Treaty was signed. But this is in fact a follow-up text integrated in the European Union legal order. And indeed, the intention, the objective of the directive is to establish the member state responsible for the examination of an asylum request. But again, I mean, the reference is in your file, so you can check it and can read it. Complicated list of criteria. In fact, this is the list, I think I've taken it from the treaty, where you always can find very interesting, subtle definitions of what the subject is all about. And here it said it's concerning criteria for the establishment for the responsibility they run. And that's important in hierarchical order. So really you have to respect the first and then the second and then the third. And so the first point of connection, as I said, entering the territory of a member state, family considerations. It may be that an uncle or a nephew or your sister or your brother has already been provided with a right of residence in one of the member states. Then of course the first criteria is where you enter the member state, but if there is a sister of yours who already has been provided legal protection, say in Austria, so in this case of the 4 applicants here in Legraina, then it's in fact the Austrian authorities which are supposed to take over the responsibility for the case. Family considerations, possession of visa, could have been that you have already been on vacation, whatever, on study visit or whatsoever, as an intern, I don't know. But it could be that you have already a connection with one of the EU member states, which means that they know you already, because as a third country national, they know you already. So then the logic of the system, and then you refer to the state where you had already been granted earlier on a visa, although for a short visit stay. And well, that is it. That's more or less. And so that's the very simple text. However, in the practice has it given rise, the application, the interpretation has given rise to several difficulties. But again, I think essentially it has served a good purpose, and at least it creates some order in this matter. Yeah? You have questions about this one? Yes, please.
Yes, I'm just curious, what was the rationale between choosing the country, the point of entry, as the determining factor for assigning the member state responsible, as opposed to, say, the member state that has the most resources or capacity to deal with the asylum application?
You suppose then that the application will be granted and so on. Of course, the question here is people coming from the outside wanted to acquire a title of legal residence, but it's completely unsure whether they can acquire that right. And as I said, we are living now in this common space where it's not that logic that you say, hey, those countries, the most wealthy one, that's another question, in fact. That's the question of the massive influx, the Mediterranean problem indeed, where you can say that at a certain moment, the Italian authorities, the Maltese, are overwhelmed with me. And then we apply also a principle on which I will come back, the principle of burden sharing. And the idea is indeed that in that case, but only in that case, I think it is in other provision, so this is the ordinary list. And then, as always in EU legislation, there are certain exceptions, particular situations. So I think you have a good point, but in fact, this is the first logic. And in view of massive influxes, indeed, where a single authority is not able to deal with all these requests, we refer them geographically to the north, to the west, or whatever, when it comes to the Lampedusa problem. So that's more of a subsidiary character. Yeah? Other question with regard to this, it's still called, by the way, the Dublin system. It's the Dublin regulation because of this origin, this earlier text, which was an intergovernmental convention concluded in Dublin, so in Ireland. Then let's move to the next one. And that's, of course, also a tricky one, because many academics have argued that it is very risky to try to define in a regional framework, which is not the framework of the United Nations, a definition for a refugee, whereas everybody accepts that the standards of the United Nations have a supreme character, so have to be respected in all ways. But as I told you before, within the EU, it was considered appropriate to try to do it in order to be able also to include new developments with regard to the protection of asylum seekers. So not only this political background, but also other kinds of grounds of discrimination which give rise to people who are trying to find protection elsewhere in the world. So for that reason, it was considered useful, but as you can understand, in the first provision of this directive, there is a reference to respecting the conventions without prejudice to the acquis of the Convention of 1951 of Geneva. Then, as I said, the two other issues, which are typically EU reforms. And I think, although the background of the introduction of these reviews are a little bit cumbersome because they refer back to the civil war in former Yugoslavia, but this text also includes a definition of subsidiary protection and temporary protection. And subsidiary protection indeed refers to nationals of third countries, and again the origin was the Bosnians, the Croats, who without obtaining European asylum are in need of international protection. It is simple as that. So the broader category which we want to protect with regard to their private situation. So that's also a definition which has been included, and although this has been included only gradually in the legislative text, you can now easily argue that all the text of directives which we will discuss are not only applicable on asylum seekers but also on these category of people. So we not only provide them with protection but also when it comes to reception conditions, the procedures, judicial protections, they are put with regard to EU acquis at the same level. So they obtain the same degree, if you may say, same level of protection. And temporary protection also. So this is really the reference to massive influxes. Could be indeed the Mediterranean situation. So, but that means, in order to give you already one of the elements for the discussion tomorrow, that in fact this might be an argument why third country nationals in all these boats have to be protected, which is not always the case, as we all know. We like to send these people back as much as possible, but there are certain obligations which we have to respect, and so without knowing, without having examined the justification of their plea for protection, they need, and we need to provide them at least temporary protection. But temporary protection might take quite a period of time, because you have then afterwards to carefully, prudently examine the situation of the individual. So that's another one. This took quite a long time before this text of the directive, and these are only the major elements of this directive, but this is one of the major innovations, if you want, which EU law can provide when you compare it with the standards of the United Nations. The third one deals with reception, and that's relatively simple. So if a family or an individual apply, could also be single minor people, which also happens unfortunately in situations of warfare. So minor people who got lost from their family and they present themselves, and I mean, you can imagine the humanitarian situation. Well, these are in fact one of the issues which are mentioned in this directive, which has to be respected with regard to individual application for asylum. So you have to provide housing, food, education, access to medical and social care, and even access to the labor market after a certain period of time. So the idea is that with regard to the procedures, the examination of an application for asylum should take at a maximum 11 months. There are possibilities to have that period extended, but for humanitarian reasons and also not to leave these people in a situation of where they are not aware of what their future situation will be, uncertainty. So we have to try to limit as much as possible the period which a member state can use for the applications for asylum, so that's 11 months. But it could easily be, however, here we have to do also with a margin of discretion for the individual member states, because, well, for example, in Greece, in the situation of the economic crisis, you can imagine that this is rather difficult to apply, that you will have necessarily to allow third country nationals who have made an application for asylum to enter the labor market. You can imagine that that gives rise to complex situations, in situations for high unemployment in the individual member states. So this is clearly the idea, applied in a certain degree, but not as an absolute obligation. And then the procedures, of course, is also clear. In fact, it's all are elements of an integral system. There is a separate text which is focusing on the procedures which have to be respected, and that is, of course, well, the period of 11 months, as I said, the elements regarding judicial protection, or at least legal protection. You have to be able to, once your request is dismissed, you have to be able to address yourself to an independent organ in a sort of appeal procedure. And there are also arguments listed which entitle a member state who has granted the situation of asylum enables the member state to withdraw that status. And certainly you can imagine which kind of situations we are here referring to, because we have dealt with them already several times during our discussions this week, which are the clear grounds for a member state to put an end to freedom and liberalization. So there are certain national interests at a certain moment involved which justify a member state to withdraw. Public order, public security, might even be public health, although I'm not aware of these, but if you commit acts of crime during the period that you have been allowed, serious crime, I mean here's a difference between stealing a bicycle, that's the typical example in the Netherlands then, or really commit an act of international crime, corruption, fraud, women trafficking or whatsoever, then this might entitle you to withdraw the permit, which is of course rather logical. So that's also an element which is necessary to involve in this procedure. And this is the one which I will come back to later. So that means that when we have the responsible member state, when we have established who is the responsible member state, which are the conditions for reception, which has to be respected, how are the procedures working, and the definition of the refugee, all in all that provides a sort of minimum acquis which you can apply with regard to asylum of requests. Now, in order to conclude this part of our discussion, so when I refer back to these simple kind of elements, I can tell you that it indeed took us 10 years' time to try to find the best solutions, arrangement to deal with these issues. The question, of course, is to what extent is it properly applied? So the ambition, as I told you, was to create a common system. But certainly the problem will be that individual member states allow themselves nevertheless different interpretations. So you can come to different interpretations, different outcomes even, which is of course contrary to this idea of within the EU, because that's the consequence of the first ruling on the responsible member state. In the EU, you can only, in fact, have one chance, whereas earlier you could address yourself to all the individual member states. So in the period of the 70s of the last century, for example, my country had a very liberal regime for asylum seekers. There were many people who were coming to the Netherlands. If they were not well received in Denmark, in Germany or England or whatever, they could come to another member state. Whereas now, of course, the idea is that you can only have one chance. That's the consequence of the logic, is it the logic, of having one human space. So it's, you can only have one chance, and then it may, notwithstanding the fact that we have tried really to fully harmonize all the elements, detailed definitions of what an asylum seeker is, and the scope of the family, perhaps that's also an interesting aspect. I told you last, when was it, Tuesday, that we interpret the scope of family members in a rather large manner. Huh? So free movement for workers, independence implies also they are allowed family reunification, bring the family members. And we had a sheet when I showed you, of course, not only the primary beneficiary, but also his spouse, also his partner. You remember partner? What is a partner? That's a kind of, it's not in a rather formal note. Nevertheless, when you can really demonstrate him at a sustainable relation, you can invoke that kind. Then there was a reference to ascendants and to descendants. In fact, all those family members who are dependent, economically dependent of the primary beneficiary, can be included more or less in this notion of family members. That is a little bit different here. So when we try to draft the definition of family members, and you will find it in the Family Reunification Directive, which we will, by the way, encounter in the second hour of our discussion, then the scope is limited. It is the wife, the spouse. So the formal, and that's a kind of concept which everybody knows what it more or less is. Then it's only a minor children. And it's minor children, of course, of the asylum seeker. And there is also a reference, because that could happen, that these are minor children of the spouse. That can happen. I mean, they met each other somewhat later. So not only the man, but also the women has her own minor children. But there clearly the reference is to minority. So that's the age which the responsible member state applies in the context of adults or minor. So in the Netherlands that could be 18, in other member states it could be 21. And then you can see that there are certain differences, although we tried really to provide for a complete system. So although all these nice details, in the end a common system might, when you apply it in practice, gives rise to different situations. And that in fact can hardly be accepted. And to that extent I think in the EU, but really these are exceptional cases, but we still have still some work to do. Because although in the course of 10 years' time we have provided for this nice legislative system, there are still certain lacuna to be covered. When it comes to, yes, the point on the burden sharing, I wanted to make still 2 points here. Indeed, burden sharing is something which came up, and I'm afraid also in the light of the experiences with the civil war in Yugoslavia, how to deal with a massive influx in 1 or 2 member states. The treaty prescribes the principle of burden sharing, not only from a physical perspective, but also the financial perspective. The European Union has even provided for refugee funds, but they were really minor funds. I mean, a couple of million euro or whatsoever. But the assumption has always been that, in fact, as an expression of solidarity, that the member states join forces and take over a number of applicants in a situation where the first responsible member state is overwhelmed by applicants. In practice, as we all know, this is not completely applied. And that is a problem, of course. On the other hand, the influx from asylum seekers, illegal migrants, does not only take place here in the Mediterranean area or at the Greek-Turkish border, but in fact they appear each and everywhere, also in the Nordic countries, still in Belgium, still in the Netherlands. So, but this is an issue, I think, which still has to be better coordinated. And how to better coordinate in a situation where, well, okay, the Commission, in the process of drafting all these texts, had the right of initiative. So far, so good. But the Commission has not the power or the competence to address instructions to the member state to take this attitude, as is the situation by now more or less in the economic domain when it comes to examination of the yearly budgets, for example, which member states have to present to the Commission, and then the Commission can provide for guidelines, which in fact are binding. So this situation in this particular area apparently is being considered a little bit too sensitive. Nevertheless, some coordination takes place, and funny enough, that's one of the last founded agencies of the EU, and that's called the EASO, the European Asylum Support Office. I happen to know the director of that support office rather well. He was a former colleague of mine from the Ministry of Security and Justice in The Hague. And this is an agency which has been founded, well, I have to check my papers, but I think it's only 4 years ago. And the seat is in Malta. And they help member states support, make some research, and try to coordinate. But I mean, it's difficult, of course, to also for the director of this agency, EASO, it's a small agency, by the way, to really address binding instructions to all member states. So that's not really the situation. Yeah. So, but nevertheless, burden sharing is an important principle, as is this idea of assistance in the process of implementation. Now, there is a final one with regard to the chapter on asylum, and this is, of course, what is the situation of those poor people whose request, for one reason or another, has been simply rejected. Of course, they have to be sent back. Many practices show that people are simply left in the streets, so you simply take away all the facilities with regard to housing, education, medical care. And so in many cases, unfortunately, it happens that these people find themselves in the street of your nice town or capital. But of course, it would be better to really reflect commonly about what we have to do with these people. And that's also an element of our tomorrow's discussion. And this is also a reference to the fact there is no single answer possible to all these difficulties. But here I mentioned a number of issues which have now been practiced at the EU level. You can imagine the last one, the second dot, is the most easy one. Because the EU primarily is an economic power. And there are many third countries who have an interest to conclude interesting trade agreements with the European Union. Or for technical assistance or for whatever. The fact that the EU is nevertheless, globally speaking, if it's not the first economic power in the world, then it's the second or the third. So it makes it an attractive partner to make agreements, to conclude agreements with regard to privileges and these kind of things. Now the practice of the EU is to connect to these negotiations clauses with regard to readmission. So it's not only privileged and a deduction of tariffs and customs duty and whatsoever, but there are also clauses which says that the parties are obliged to readmit people illegally, to be considered illegal migrants in one of the member states of the European Union. And I remember that the first example here, which was a rather strange story, was the country Australia. So in Australia, while negotiations going on, economic negotiations, very interesting, trade negotiations, all kinds of niceties in there. And then the EU delegate imposed a readmission clause. And the Australians were completely surprised, outraged, and in the end they were very angry. And they didn't want to accept a clause, readmission clause, which is readmission of illegal Australians in your country. I can hardly imagine that could be the case. And they simply refused to cooperate. And that meant that negotiations were delayed, suspended, and whatsoever. In the end, when it became more or less normal practice that the European Union tried to achieve this kind of objective connected to economic relations with other countries, also the Australians, the more so because the clause is mutual. It's not only focusing on illegal Australians which have been found in one of the member states of the EU, but it's also referring to illegal residents of one of the EU member states in Australia, where then the European Union formally takes an obligation to readmit themselves on our territory. So the return and readmission is a whole practice. It's a huge practice. It's Moldova, Ukraine. I think also with Russia there is a rather extensive, intensive partnership agreement, and I suppose also in that context we have included this kind of clauses. The other one is of course more interesting to the extent that it tries to solve the problem. So if somebody is not considered to be an asylum seeker and his or her continuous stay has been refused, for example, to get access to the labor market, then the issue is, of course, these people have to be returned, have to resettle themselves somewhere, and then the issue is how can we achieve that goal. So in principle it should be people who have not to fear for their life once they are sent back. In practice that also gives rise to a lot of legal proceedings. You can imagine that when you have to wait for an answer after 11 months, the answer is a refusal, and with your whole family you have to pack your things, you are sent back to the country where you in fact have demonstrated not to be loyal to, because you presented in Europe and for asylum. So when these people invoke, oh, but I have to fear for my life, etc., gives rise to new legal proceedings. And this, of course, is the most difficult one, the most difficult component. How to allow these people to resettle in their, is it not in their home country, then at least in the neighborhood. These are discussions, for example, which have started with Turkey. And you can imagine a little bit Turkey with all the problems Turkey also has. But in this difficult area with all the neighboring countries, Georgia, Iraq, Syria, that you can imagine that Turkey might be able to create safe havens for these people, not only where these people can find refuge before they are trying to apply in the European Union, but also with regard to resettlement. Not easy, and you ask, of course, a lot of these authorities, but this is also a difficult problem. So those people whose requests have been refused, they need some assistance in order to be reintegrated. Is it not in their home country, then somewhere else in the world, and that's of course another difficult aspect. Okay, that is, I think, what I wanted to discuss with you with regard to asylum. So let's allow us to have a short break, and then we will come back in 20 minutes? Okay. Okay, shall we continue our meeting? First of all, I wanted to ask you whether there are questions which we should take. There will be also, by the way, an opportunity, because we are now in the midst of the subject matter which we will deal with tomorrow as well. So we can also come back to certain issues tomorrow, but if there are no urgent questions. Then the final thing I wanted to add in the connection of the external relations, that you should be aware there are also good contacts with the UN, the High Commissioner for Refugees in Geneva. So I suppose that in Brussels and also in the capitals, good contacts with the UN. However, from an operational perspective, of course, it's the member states who have to do this job through the EU. And of course, the advantages of working in the framework of the EU is that you can have leverage also on third countries when you are discussing the economic arrangements, and you can just combine in the economic agenda also issues regarding readmission and return of illegal people. It is as it is. Well, when we then turn to the other topic, immigration or migration, to a certain extent the elements are similar to be compared, but as a problematic it is nevertheless completely different. With regard to asylum, we have committed ourselves to this standard. All those people having the nationality of a third country, those in trouble, you have to provide them international and protection. That is not the case with migration. Migration is a matter which is completely in the ambit of the competence and the responsibilities of the individual member states. Whether I allow somebody to, and again, the focus is, and the framework of reference are third country nationals. Whether I allow an engineer from India or a technician from Ukraine to enter the labor market in the Netherlands, it's a question to be decided by the Dutch authorities. There are no specific international standards, prescriptions who really can impose a certain... So that's something which is important to keep in mind. But certainly it's connected to asylum, especially when combat of crime is involved, when it's indeed, when we are referring to people illegally on the move. In a way also economic refugees. You all know that, of course, if you're looking for a better future, you can of course invoke the status of asylum seeker, but it could be easily to reject such a request because you are not the asylum seeker properly speaking. So also the economic refugee is to be considered as an illegal migrant at a certain moment. So that makes the issue a little bit complicated. What further complicates the matter in the context of the EU, and then we have to return to the concept of the internal market, there is a reference in the treaty, deliberately included upon the request of several member states, that the responsibility to admit third country nationals on the territory of a member state is a national competence. So far so good. However, these national traditions or national behavior can really have an impact on the working of the internal market. For example, which was a clear example, I think, and the Spanish students, are there Spanish students in this class? Unfortunately not. But Spain, in view of his traditional, historical relation with the countries in Southern America, they have practiced as an attitude to give free access of inhabitants of one of the Spanish-speaking countries in the Southern Americas to enter Spain, to be naturalized, which means they get the identity of an EU citizen, and then, of course, they can, why not, profit from all the advantages, sometimes disadvantages, of the internal market. So, on the one hand, the member states are very keen to keep in their own hands the power to decide about admission, yes or no, but indirectly we are all influenced by the effect of the internal market. Similarly, the situation of the overseas countries of my country in the Caribbean. So there are not that many people living in the Caribbean having a Dutch nationality, but there are several ones who could, in principle, travel to the Netherlands, and they, of course they are admitted in the Netherlands because they have the Dutch nationality, and from there on, if they like, they can then move further on the internal market. So you can see here that this internal market, one way or the other, requires us to settle a number of standards, how to deal with these issues. Then, of course, is the question, do we not have an interest to cooperate at the EU level with regard to legal migration? In practice, that's certainly what is the practice of the EU. First thing we've paid attention to is combat of illegal immigration. Of course, the first instruments when the whole Justice, Home Affairs cooperation were introduced in the Treaty of Maastricht, the first attention with regard to migration was to prevention of illegal immigration. So reinforcing external borders, Frontex and all these issues. But you can argue, of course, at a certain moment, and that might be also an element which we can discuss tomorrow, that there's a certain logic even to discuss the subject matter of legal migration at the level of the EU. Because, well, you know them certainly from your discussions at home, we live in a globalized world. Free movement is the normal factor these days of our societies. The demographic developments require us to find people to take jobs which our own nationals do not simply want to fulfill. So in the Netherlands we still have an important, sector, industrial sector, where you can find jobs for which Dutch candidates will not simply apply. So we need a certain working force coming from a third country. And of course the focus has always been in this context. By the way, it's a limited context because, again, member states, they want to be responsible themselves for admission in their country. But the focus has been on high-level qualified people coming from the international community, and then the IT experts and these kind of things. Is it not better to deal and to negotiate eventually with third countries with regard to the admission of technical engineers coming from India, Pakistan, wherever they come from? Is it not better to organize this in the context of the European Union? Now, a beginning has been made of this legislation. Simply, when I present the sheets, I can then also present the legislative text. In fact, what we have done is a first step approach. So first of all, the first element to take into account, member states themselves, they are and they will continue to be responsible for legal migration. However, we have facilitated the residents, so we have thought and reflected, which is a good thing, I think, about rights of third country nationals who have legal residence in one of the member states. You can leave all these issues to the member states themselves, but what has been tried is to provide for a common denominator. For example, it should not be, if you allow a third country national to come on your labor market, and you give the person not only a permit for residence but also a working permit, then you should provide also for a certain environment, which means housing, education, family reunification, etc., etc. A situation deplorable as it is, which we have experienced, I think, in all our member states, is the substandard conditions which are provided to third country nationals sometimes, with regard to deplorable housing, salaries under the minimum level which is applied in the individual member state. So to that extent, the idea has been that we should provide for a common denominator. This is a level at the minimum level, and of course member states themselves can, in a complementary manner, provide for more favorable treatment of third country nationals, but we have to provide for a sort of minimum level. The more interesting aspect is so far, because this is always also a young domain of cooperation, is to what extent a third country national having legal residence in a member state is allowed indeed to enter the internal market. Because one way or another, at the moment, a third country national, a Russian engineer who lives in Belgium for 10 years, has brought his family, children are going to Belgian schools, he's paying his social, his social and fiscal services, he's completely behaving in conformity with all the rules, etc., etc. This might at a certain moment also become a citizen who really integrates in his and her environment. So to that extent, the idea has been that, of course, necessarily, once we allow third country nationals to be admitted in the European Union, and again, as a consequence of the existence of this internal market, we have to take the next step, and that is to what extent we allow third country nationals to enter this internal market. Now, developments are not going that fast, but remember, before the directive, which provides for the possibility for third country nationals having legal residence in a member state, after 5 years, they should be given the possibility to indeed move with their family to another member state. So earlier on, when a member state, the Netherlands, would have admitted the Indian engineer on the Dutch territory in order to be employed at Philips, for example, that could be an example, the permit to stay in the EU was simply restricted and limited to the territory of the Netherlands. So this guy or woman, qualities as he or she might have, is not entitled to move from the Netherlands to Belgium. Now, it is not so long ago that then indeed a directive has been adopted which allows legal residence after a period of 5 years to enter the internal market and to try to find a still better future elsewhere in the European Union. Certain conditions are set here. So whereas, as we discussed on Tuesday, an EU national can enter the internal market and can move to another member state and in order to look for a job, the restriction with regard to third country nationals is that they can allow to move to another member state under the condition that they have already more or less a labor contract in that second member state to be visited by them. And in this context, I have a number of sheets I wanted to present to you. So first of all, these are the issues. So when it comes to legal migration, so it's the more difficult dimension of the discussion of this afternoon, how to arrange this as a common European level. It's the common denominator at the minimum level where we have to provide for. Of course, residence permits, you have to formalize, of course, the stay of certain country. You have to make arrangements with regard to the procedures, how to do it, which form, etc., etc. And more importantly, which are the rights of third country nationals residing legally in a member state. And again, not as an absolute regime, but as a minimum regime, in order to prevent underpayment and bad housing and all these kind of circumstances. So this is a first step approach. And the family reunification element is of course of important. They also should have the right to bring their family members. And last but not least, and this is a funny topic, integration. Integration was not on the program when we started the cooperation in Western Europe in the 50s, in the 60s. Many Italian people came to the Netherlands, Dutch people were sent to Germany, but there was not provided in an integration program for Italian people who started a restaurant, for example, a lovely pizza restaurant or whatsoever. So there was not an idea, not a thought about how to allow these people to know a little bit the culture, the history, the language, in order to allow them to integrate in these new environment. But obviously, when we are discussing this from a global perspective, when we, as we discussed, referring to Afghanistan, people coming from Central Africa, North Africa, the Middle East, wherever they come from, of course, they come from completely different civilizations, other traditions, other cultures, etc. So we have to provide for methods of integration. Now, just to put here the question, what do you think the EU can achieve on this point when it comes to integration? So the Commission, again, having the right of initiative in all these nice cases, what do they think at? When it comes to integration, well, in fact, I've already touched upon a certain numbers of subject matter. Where do you think at? So the Commission, civil servant in Brussels, hey, when this Indian engineer enters the EU, we should provide for, well, language courses, how to get to know the history, the culture, etc., the constitutional system. Does the person has a right of vote? What we discussed during our European citizen discussions, has he the right to vote or to present himself as a candidate for the local election, for example? So to facilitate integration in that is a difficult point. So there are many, if you look into all the papers and the websites and you follow all the materials, this is an interesting topic, many discussions, but no hardware, nothing as hardware. So the Commission recommends this and that. It's discussed in the Justice and Home Affairs Council, but there is in fact not a certain acquis. So that we can take already as a point we have dealt with. The other one is this one. Just to finish this one. So the conditions for entry and residence have been harmonized, clear. Which procedure, which form, etc., etc. Also deadlines, etc. So the permit which they get in their passport has been harmonized. A common document, a common residence permit, that's fine. The rights of third countries, that's another issue. It's a more serious issue. And family reunification. I want to present you these two categories: the rights of third country nationals, and then family reunification. These are the two directives. As you may see, they date back, the first step approach, they date back to the year 2003. And as I said, I was, because at that time I was the legal advisor on the Dutch permanent representation in Brussels, I was a little bit surprised that we succeeded in adopting this directive, because as I said, under certain conditions, third country nationals after 5 years of legal residence are entitled to enter the internal market under the condition that they already have in their pocket, so to say, a labor contract. But nevertheless, and that's really a different situation compared to earlier on, when simply the permit was restricted to the territory of the member states involved. Family reunification came on top of that, and the idea of this directive is it's 5 years. 5 years, I think, generally speaking, is a term which is used in many of our member states when you indeed enter into a situation where a foreigner may be entitled to naturalize. So in the Netherlands we have this period of 5 years which enables a person to apply, for example, the Dutch nationality. And I think that this period has been selected because of this general practice in many member states of the European Union. And then the idea clearly is, in fact, they should be dealt with at the same footing as EU migrant people. That's the, if you read this directive, it's not a very lengthy text. There is an Article 14, and that expresses the idea of equal treatment. And in fact, in all the basics, it's not, by the way, referring to the right to vote in local elections. That has been left to the member states to decide upon. But with regard to, well, the traditional elements, education, housing, medical care, and whatever, they have to be treated equally compared to the EU nationals. And family reunification has provided in this more restricted scope of what a family is supposed to be. So apart from the beneficiary, him or herself, the spouse, or the formal concept of the spouse, the wife or the husband, and then next to that, purely minor children. That doesn't mean that all the other members of a family who are dependent, which is the larger concept practiced in the internal market, that they are not allowed to enter the member state, but that is a purely national decision of the member state involved. So all these issues had as a meaning to provide for a minimum level, and it leaves to the member states the possibility to take a more favorable position to these immigrants. Yeah, that's the reference to member states may. So there's a category of family members are, and then family may, and then all the others are listed. These are, in fact, as far as I'm concerned, the most important text with regard to legal migration, and it illustrates that member states in this domain also consider themselves as the primary competent authority, so they have not a huge interest to discuss and harmonize these matters at the EU level, but here typically consequences again of the functioning, the working of the internal market, which requires in a way these matters to be taken. Then I said, indeed, when it comes to legal migration, do we not have an own interest to discuss these issues at the EU level? The engineers or seasonal workers, for example. And indeed, since a couple of years, we have concluded or adopted a number of legislative texts with regard to highly qualified employment people, and also the single permanent directive. So once you yourself want to employ a third country national on your in your territory, on your own labor market, and you want to provide this person also with a legal capacity of residence, then there is a directive which in fact has as its purpose to speed up the procedure and to facilitate this transaction as much as possible. Now you see highly qualified employment. What does that mean? Well, my recommendation is take a look in the text. In fact, what we are hinting at is well-trained people with well, it's not said explicitly an academic education, but higher educated people. And the idea is we need these people, so that was a reason to facilitate as much as possible their entry and the residence on the territory of the EU. It's called blue card. I don't know exactly why it's blue card. Probably they have in their passport a blue card. I don't know exactly how this works, but so, and then in combination with the second one, it's indeed relatively easy and smoothly and fast to get a permit to come to one of the member states of the EU. Other examples which I have not listed well, have to do with the admission of non-EU nationals for the purpose of studies. Pupil exchange, well, in fact, it's a reference to interns, unremunerated training or voluntary service. So that's also, and seasonal workers, that's another. In 2005, there was a directive related to seasonal work. You can, these are issues where member states came to the conclusion that's a mutual interest. So let's try to provide for a common regime for people who are only working here for a longer period than you can reach with the visa, but seasonal workers, so those people stay on your territory for 6 months or so, that you can provide all the procedures reasonably easy. Similarly, for researchers, in 2005, a directive has been adopted, and that also implies a fast-track procedure for the admission of non-EU researchers. And then the conditions always in these domains are, whether it is for students or for voluntary service or seasonal workers or the researchers, the same grounds which we have met and discussed already in the context of the market, sufficient financial resources and the possession of a health insurance. And when it comes to sustainable residence, there is a reference to the knowledge of the language in question. So that is also a requirement mentioned in these directives. When it comes to research, well, you can really take a closer look. What does that imply? Research these days can easily imply only knowledge of the English language, isn't it? Also, in case researchers are admitted in the Netherlands, it doesn't mean necessarily that when you can profit from this directive to become a researcher under this wonderful arrangement, that then the knowledge of the Dutch language is required, but it's better to put the question, what is your track record with regard to knowledge of the English language? So these are issues when it comes to legal migration, so the more difficult part. The other part is, and I come back to that one as well, is the illegal immigration. And in a way, this problematic presents, of course, similar characteristics with the discussion we had with asylum seekers, whose requests and application has been dismissed, and where we have to try to find solutions to repatriate them back to their home country, or at least to try to resettle them in an appropriate manner. Yeah? Questions on this? Legal migration, yes, please? Yeah?
In general, it also connects to things we said the other day. I was wondering what your opinion was on the role of the European Court of Justice in the evolution of EU law in this field. Because my impression is that the limitations that have been posed on the ECJ's jurisdiction in this field have hindered the development of a meaningful case law. And instead, with the Treaty of Lisbon starting in 2008 and with the elimination of these limitations, we have been seeing more decisions in this area and also very important decisions.
Yeah.
So I just was wondering what your impression was on
Yeah. Well, as always, I think the role of the Court of Justice is very important. It took indeed a while before this practice came up, because before the court was able to develop a sort of doctrine. But one of their most important decisions so far was the annulment of the first version of the Family Reunification Directive. Do you remember that one? So at that time, the scope of application of the notion of family was considered by the court, which is rather interesting, to say the least, was considered to be contrary to the human rights standards of the European Convention, for example. So the Council, because at that time the co-decision procedure was not as yet of application. So I have taught you and discussed with you the latest state of play. But when this Family Reunification Directive was adopted, it was purely the competence of the Council to adopt this text with unanimity. And the text which was adopted by a unanimous vote in the Council was presented by the European Parliament at that time to the Court of Justice, which is an annulment procedure. So in the EU judicial system, one institution has the possibility to attack the legality of an act of another institution, and in the case of the European Parliament, even without the Parliament is obliged to show a specific interest to do that. Parliament is involved in decision making. Lately now, through the application of co-decision, earlier on, because of it was involved by through the possibility to deliver an opinion. And the Parliament took this first text of a directive, adopted, fully fledged adopted to the court, and indeed it succeeded. And since then, the Dublin regulation, there are many examples of a practice which show that also in this context, and luckily that is the case, the Court of Justice plays an important role in this area. So it's right that you mentioned this example, and I can think, perhaps you can think at other examples. For me, so far at least, the Family Reunification, which was completely annulled at the request of European Parliament, is the most important one. Do you have other examples in mind, perhaps?
I was thinking of cases answering requests for preliminary ruling coming from the states.
Yes.
So Eldridi in matters of,
yes, of course.
Expulsion,
Yeah.
recently another decision, I can't remember the name, on administrative detention of foreigners, but as well in asylum matters, there's a dialogue which is developing with the European Court.
And then it could be that the interests of third country nationals are involved. In fact, another important court decision refers to terrorism. Complicated but interesting it is. So the Security Council, in the context of the combat of terrorism, had issued resolutions, and you know these texts, where they have put certain personalities or organizations on a sort of blacklist, which should be prevented to enter the territory, or to freeze the financial resource banking accounts of suspects of acts of crime, terrorism, etc., etc. This resolution of the United Nations, by the way, was binding for all the member states of the United Nations, was also implemented in the EU through a rather complicated procedure, but nevertheless it was implemented by the EU, and then appeared in that list. It was simply copied from the list of the Security Council themselves, but in the EU attacked by certain people who appeared on that list. And their argument was, I don't know exactly how to express that correct, but the argument of those people, so presumed to be a potential or active terrorists or members of a terrorist organization, that in their situation their human rights were violated. The auditur, what is this in the French or in the English, what is the real so the right to be heard before a restrictive measure is adopted. You have the right to be heard, to give an answer, etc., etc. Well, you can imagine that, of course, when it comes to combat of crime and combat more particularly of terrorists, that people are not, authorities are not tempted to consult these people on beforehand, especially when it comes to freezing of banking accounts, because the moment they get the information about what's going to happen, then they take away, etc., they withdraw the money from these bank accounts. Nevertheless, this case was also attacked before in the tribunal of first instance in the first thing, and then appealed to it by the Court of Justice. And indeed, in certain circumstances, the court was of the opinion that certain human fundamental rights of people suspect of terrorists, that when the authorities were not able to demonstrate that the suspicion was justified, so to say. So to that extent, indirectly, the Court of Justice in Luxembourg corrected a text which was issued by the Security Council. So this gave rise to very interesting discussions about the relationship between European law and United Nations law. And of course, the outcome should be, we have to respect the resolution issued by the Security Council. However, then it comes to the core business of the rule of law, internationally speaking, which is indeed the rule of law and human rights and fundamental rights. So indirectly, this is also an example where the court corrected the attitude taken by the Security Council without explicitly saying so. But that's also another Cadi case, and there are more in that. So where the member states or the EU, or because the author of the legislative measure, the implementation of security, was the Council. So where the Council was not able to demonstrate a first proof of suspicion of a commitment and an involvement of these persons in acts of crime or activities of terrorist organizations. So it's a good point. And by the way, tomorrow, but unfortunately you will have another lecture by the Chinese guest lecturer. I will have a meeting with these Thai people. They are members of the administrative chamber of the Supreme Court in Bangkok. And I will discuss with them a number of issues related to the EU judicial system. I will certainly mention the impact the doctrine of the Court of Justice has for the whole development, interpretation of the EU legal order. So thank you for the observation. It's an important one. So with regard to legal migration, a relatively small acquis, nevertheless I think it's rather important, and it will be further developed. In what sense remains to be seen. Perhaps tomorrow, after our presentations, we can have further inspiration in this area. Question?
Yes, I had a question about family reunification specifically.
Yes.
I'm not very familiar with the precise rules. So when it comes to allowing an immigrant spouse to join that immigrant in the European Union, what are the laws surrounding the recognition of marriage? How does that work? Does it depend on the member state, European Union law?
No, it's not European Union law, certainly not. So civil law, it's the area of civil law, is an area which is clearly in the domain of the national competences. What the EU does is to recognize the outcome, but yeah, the outcome not so much of national law, but of judgments, designate the competent judge to take note of a conflict in the area of family law. So you cannot say that we have recognized the validity of each other's family law, for example. Nevertheless, indirectly we are doing so, because the reference is to a spouse, and I do not know the exact wording, but I can give you, I think it's pretty sure, in accordance with national law. So we simply accept the outcome of national law, because what's the background of your question? I mean, what we do not what we do not recognize are marriages of certain international with several spouses and whatsoever. How do you call that in English? Polygamy. Polygamy. Voilà, c'est ça. So that's something which we do not recognize. But in the context of the standards and practices in the EU, we recognize simply the outcome of family without having adopted certain legislative measures in that area.
So it's possible that one country could admit a same-sex couple and another country and another member state could not?
A same-sex couple, I'm afraid so. Yes, that would be possible, yeah. So let me think, what would the situation be? Because this is an area exactly where there are quite a lot of differences. I mean, the one member state is more open towards recognizing these kind of partnership of people of the same sex, so to say. When this couple presents itself to you, in this case then having a certain nationality, it's an interesting case. I think in the Netherlands they would have no problems. But it may be, I don't know, in Italy, for example, would that be admitted? I'm wondering. I'm not pretty sure. And I think that demonstrates it's another defect in our system, that although we use the same terminology, the background is slightly different. Even the outcome of your request could be a different one. In Italy, it will not be allowed, I think. I don't know what the situation in Italy is, but perhaps we should ask the professor, because perhaps he knows that. But yeah, I think that might be a consequence, yeah. Well, we have to check perhaps the wording. So take a moment and check the wording of the Family Reunification Directive, with reference to spouse, yeah. Interesting point. Take the micro, please, because
European law as whole doesn't recognize such.
No. This is not an area where the EU is competent to deal with. We are not even competent to deal with contract law. Why not? Well, it's considered to be national domain, although it has all kinds of implications for movement of goods, persons, and whatsoever. So we recognize the outcome of judgment with regard to divorces and custody over children, but we are not allowed to harmonize in this area. And there is even a reference in the article that to the extent there is a possibility to harmonize in the domain of private law, it's unanimity which is prescribed. So just to prevent these kind of different outcomes within the EU. So when this issue would come up in the EU, let's commonly recognize partnerships of people having the same sex. There will not be a directive because it will be accepted by a number of member states, will be refused by the other ones, and unanimity is not obtained, so to say. So it's a good point. It's another point which demonstrates indeed by applying all these nice mechanisms, you can arrive at different outcomes, which is a little bit cumbersome, but that's the situation. Well, that's immigration. What do I still have and what I wanted to explain to you? Well, in fact, we try to bring this discussion to a conclusion, and we will come back to it tomorrow, because in my perspective, this problem, whether it's presented from the aspect of asylum seekers or illegal immigration, it is a subject matter which will not be solved in the short-term period of time. So, and more seriously, and again, I started to refer to the NATO summit, let's do this once more, as long as we are confronted with serious threats for the security which inspire people to find protection somewhere else, and with regard to poverty situation, which is of course the background of the migration, the boat people coming from Northern Africa to Europe, as long as we are still confronted with difficulties with regard to differences in standards of living, different standards of development, prosperity here, poverty over there. This will be a problem which will stay with us for a while. I mentioned to you, but I think I really should say, I'm not sure whether it's completely right, but I have read once 500,000 more or less applicants in 2013 for asylum, but also 500,000 applicants, people who were suspected from illegal immigration. It is not that much of a problem, relatively speaking, but nevertheless it has a serious impact on our society. We should be obliged or committed to give these people a residence on our territory. So to the extent that all these situations, internationally speaking, are not equal to our standards, or US standards, or Australian, Canadian standards, there will be this problem with us. And I think hopefully tomorrow we will find at least a sort of new kind of perspectives, but as far as I'm concerned, they have a different character. I think we should put a lot of energy in technical assistance, investments in countries of origin, of course, to prevent these people to leave their country. It could also be that you allow the boat people the legal residence by allowing them to work on the labor market. Let's see what the discussion tomorrow. I think it's a combination of measures which is for the moment best, but I do not have the impression that we do. By doing so, we'll solve the problem in a satisfactory manner. So let's try to find these final conclusions in our session tomorrow. That means I still have a final question for you, which is an interesting one. After having listened to this kind of presentation, we are living in a nice world here, at least stable, peaceful environment, and a human space, all member states being committed to the standards of the UN Human Rights Convention, but also for us, more important, on Strasbourg, the Council of Europe. The question has been put on the table at a certain moment, and I'll explain later in the past, whether it should be considered acceptable that an EU national presents an application for asylum in another member state, or should we in fact accept a common position in such a situation that these requests are considered completely non-admissible. So do you think, in view of what you said about the niceties of our society, that we should exclude that an EU national presents an application for asylum in another member state? What should be your answer to such a situation? Several answers can be right answers. What is your idea on this?
There is no provision in the regulation to prevent a second state to examine such a file.
Yeah, but this is a request of an EU national. An EU. So that was the particularity of this final question before you will believe it. So, because the question has been during the negotiations with regard to the Amsterdam Treaty, because I recollect that very well still. So an EU national, a French national presents in the Netherlands a request for asylum. And his argument should be, in France, I have feared for my life. There's a threat for respect of my life. Is that a feasible situation or completely unsinkable? Yes, please.
I don't think that it's unthinkable, because now with the rise of so many right-wing parties across Europe and the conflicts that arrive, I mean, here in Greece we have violent conflicts between members of different political areas. So I don't think that an EU citizen as a political refugee is a far-fetched notion, and I believe that since there isn't some provision preventing an EU citizen from doing so, that it's something to be discussed, it's something to be examined.
Okay.
Or even if it is rejected, for it to be within good reason.
Yeah. What about you?
I would have to agree, even if things were completely peaceful in Europe, which, as you pointed out, they aren't necessarily, conflict can arise so quickly and so unexpectedly that it wouldn't make sense to rule out such a provision for the future. More on top of that, in addition to political conflict, there are racial tensions, minority tensions. The Roma all over Europe are persecuted in many different ways. So it would make sense for Roma, being EU citizens, to be able to apply for asylum, although of course there are a lot of complications with that situation as well. So I think it would be very short-sighted and very myopic to rule out such a provision.
Somebody else, because what you are doing is to undermine the uniformity of the standards which we all have accepted, and so yeah, to that extent, I mean, it's also a sort of a deviation from climate in one member state is supposed to be completely identical to the climate in other member states. So you are inclined to think that that is not the case.
In these issues, it is not the case. It most definitely isn't. It's like comparing the Netherlands to Greece in terms of the.
It's a little bit clear what the outcome will be. What's your contribution here?
We started from the first lecture, the right of free movement.
Yes.
So if we rely on the right of free movement and try to conduct business and live any part of the member state, so there is no point to seek asylum or refuge. He can simply move to a Greek person facing some problem. He can simply move to another member state without asking any asylum or refuge, because it is his right of free movement.
It's also a good evidence.
Yes, but as a counter-argument, if he is persecuted in his state, there is the cooperation we talked about yesterday, so he can be extradited in the other member state, so he's not safe.
So now comes the proposal, and it has happened. So in practice, there is a text that will be rejected, and I shall read you the particular sentence. When we were negotiating the terms of the Amsterdam Treaty, it is the May, there was a conflict between Spain topic was about the protection provided by Belgian authorities to suspects of terrorism in the Basque area. So, what has happened? So, the Spanish Prime Minister, all these meetings where high political level, now, he was outrageous and even threatened to stop and to suspend the negotiating whatsoever. Because he thought it unthinkable that in the EU it should be allowed that my national will be considered admissible when presented to the President of the Parliament. And that's completely contrary to the idea of the common standards and level of protection to be applied. Okay, that was of course politically understandable, and the problem became only worse because the Belgians not only provided protection for the Basques exposed terrorists, but also housing and I don't know what. And there's a certain moment, the two Basque supposed terrorists were gone, were fled away. So they were not more under control also of the Belgian authorities, and the problematic became only more serious. At that moment, Mr. Aznar presented a text of protocol, which in the legal terminology is similar to the text of the treaty, where he wanted to have stated and confirmed and underlined by all member states that it is prohibited, or perhaps not prohibited, but that application of asylum by an EU in another member state should be ab initio considered to be not admissible. What was the reaction of members of other member states? And you were hinting at that, of course, clearly. I mean, this is not so self-evident, all this. And the more so, that was, of course, an escape for member states. The Netherlands, and I was a member of the Netherlands, we had a presidency, so it was a little bit of a problem. We had already secured nice texts and so forth, and they threatened to be at least suspended the whole conclusion. So at that moment, it was, for example, Belgium apart from all our nice texts with regard to human, there is a UN convention where there is a prohibition, non refoulement, and I cannot exclude, if I would subscribe to your text, Mr. Aznar, that would mean that I could violate eventually, in an individual case, my obligation vis-à-vis the United Nations, and you cannot ask me to do that. And of course, there was some logic in that. But the problem was, of course, it was not properly speaking an asylum seeker. It was supposed to be terrorists. And terrorists, we should not allow free movement in the EU. That's okay. So when they were intercepted in court, they could have been subject to surrender procedure, European arrest warrant, but they presented an application for asylum. And then the Belgians said, supported by others, sorry, if it's not in view of our commitments with regard to EU law, the UN requires us at least to take a look at this application. So what you're asking from us is simply not possible. The outcome of all these niceties was a text, and it's more complicated than I'm reading to you now. But that's one of these nice texts of the treaty. And it's worded as follows. It's typically the diplomatic language. If a member state should decide so, that is to declare a request admissible, in that case the Council shall be immediately informed. The application shall be dealt with, notwithstanding all the circumstances, on the basis of the presumption that it's manifestly unfounded. That's the presumption. Without in effect, however, without affecting in any way, whatever the cases may be, the decision-making power of the member state level. Now, are you already able to analyze and assess the relevance of this text? So that means that in the end, this is a decision which is in the Scotland, the marginal expression of the member state. So it's drafted in a funny manner. So it shall be, this is a text
treaty law, and that the application shall be dealt with on the basis of the presumptive manifestly unfounded, however, without affecting in any way the decision matter of the member state concerned in this case. So, and after weeks of negotiating, which we're bringing on in the context and frame of global compromise, also the Spanish delegation accepted it. And fortunately, in practice, there are hardly any examples where you're right. Extremist groups, the IRA is another example. In Germany, there's of course been periods which were very seriously damaging also the interest of security. All these issues that in the 80s, the rest of German students, not here? Okay, so in Germany also was these extremist terrorist groups who threatened societies and things. So it's not excluded, but it's not. Okay, this was more or less what I wanted to discuss with you with regard to design and application. And tomorrow, hopefully, we will give this an extra value, an extra dimension. It's up to you to take the floor. Are there other comments? Questions? I hope you have more or less a good feeling about this topic. And again, so once you are back, turn on the television and the problematic